please the court, I'm Jeffrey Smith with Smith & Associates on behalf of Appellant HMA LLC, doing business as Venice Regional Medical Center. Our agreement is that we are going to have 30 minutes per side, so of my 15 minutes that I'm splitting with Justice Cantero, I will reserve 7.5 for rebuttal.
I'll let you reserve 5, but no more than 5 at 15 minutes. I won't let you reserve half. So.
Then I will reserve 5.
Okay.
The issue on appeal today is whether a special act that was first adopted by the legislature in 1959 and requires Sarasota County to reimburse all of the hospitals in the county for the indigent care that they provide is unconstitutional as the grant of a privilege to a private corporation in violation of Article 3, Section 11A12 of the Florida Constitution.
There seems to be no disagreement. There was no referendum.
There's not a disagreement as to a referendum.
Was there notice? Was there, the alternative is for the legislature to give notice?
Yeah, at the time that the act was adopted, it was properly adopted in 1959 under the 1885 Constitution. I don't think that's in dispute.
But
it didn't require a vote of the electors at the time under the 1885 Constitution.
Did they have to get another new notice in 2003 or whatever that?
They would not, Your Honor, and that's because the case law is very clear that when the legislature adopts and reincorporates at the same time, that it's considered a continuation of the original act in effect. I think that's what's important as you analyze this is kind of going back to Law School 101 on some fundamentals of statutory and constitutional construction. There's a strong presumption, obviously, of the constitutionality of the laws that the legislature enacts. If there's two possible interpretations, then the court chooses the one that upholds the law, not the one that strikes down the law. And finally, it's not the role of the court to challenge the wisdom or ferret out what they think the negative consequences may be as a policy of a particular piece of legislation. The court applies the legislation as it's written and doesn't sit in judgment of the wisdom of the legislation. That's the role of the legislature. If there's a problem with it, if it's become outdated, if it's become archaic, or if for some other reason the impact would be has proven to be too great, then the remedy is to repeal the act. I'll just pause to say the facts that are not in dispute are very limited. So to the extent we end up trying to wade into different facts, I noticed in some of the briefs there were references to Wikipedia articles or trying to kind of pull in some other facts outside the record. I don't think it's appropriate, especially on I think the one thing with the governor's office that's appropriate is I think the court has taken judicial recognition of that, but there's some references to some Wikipedia type of information.
Can I just maybe you can help me clarify some of the facts? The bulk of the indigent care that is provided is for emergency room services?
That's correct, almost all of it, yes.
And am I correct, the private hospitals have to provide indigent care, at least to stabilize people in their emergency rooms, as a condition to being able to participate in Medicaid? Is that correct?
Yes. There's a federal act and there's a state act. There's federal EMTALA and there's a state act that's similar, and it basically provides that hospitals have an obligation not to turn people away at the emergency room. And
as a condition of being able to participate in these programs? Yes,
absolutely, Your Honor. But that doesn't, none of those statutes address the issue that this act addresses, and that's compensation for the care that's provided.
But in a sense, if I understand and get it simply, the private hospitals have undertaken a duty in order to qualify for certain federal programs, and the effort under this law is to shift that operating cost to taxpayers.
I don't think so, Your Honor.
Okay,
I think
tell me why.
The EMTALA laws and the access laws deal strictly with the issue of access. And it's not access only for Medicare or Medicaid patients. It's access for anybody that shows up at the hospital. If you're a Medicare patient, Medicare pays. If you're a Medicaid patient, Medicaid pays. If you don't qualify for Medicare or Medicaid and you're an indigent patient,
You still take them? You still have to take them.
You have to take them, but there's no mechanism of payment. And this act provides that mechanism for indigent patients that aren't otherwise covered, and the patients that can't afford the care that they need.
And another fact that may not be critical to the outcome, but I'm just curious, if this provision's been in the special act for a long time, but is it only recently that the hospitals have been seeking this reimbursement?
It was in 2007 that the hospitals began to seek reimbursement.
For whatever reason, in earlier times?
Well, I won't say, I think our record is, this is one of those areas where I said we don't have a very well-developed factual record. In fact, if you look, it looks like historically there were payments made under the special act to all of the hospitals. There's record materials that reflect payments being made. The county says, oh, that was under a different act. I think we don't have a developed factual record on it.
Dispositive. I was just a little surprised that this issue had come up earlier in life.
The act's been in effect for about 50 years, and it was used at one time. And then in the late, around 2007, the early 2000s, it started not being used, and then it came up again with HCA and HMA had found out about the act through happenstance, and they said, well, we should apply for the funds that are available for the indigent care we provide.
Am I correct, though? The county would not have to make the payments to the private hospitals if they made no payments to the public hospital, correct?
No, I don't believe that is correct,
Okay.
Your Honor. I think that what the language of the act says is that private hospitals will be eligible for reimbursement in like manner.
Right.
I think the like manner is referring to the process, the procedure of how you go about billing for the services provided. And if you think about that, it makes sense, because the construction of you can only get paid for indigent care if Sarasota County's hospital, Sarasota Memorial, got paid that particular month doesn't make much sense. You say, well, I only get paid for all of the indigents who came to my hospital emergency room in the month of May because Sarasota happened to have some billing in the month of May, but in the month of June I had a lot of patients come in and I don't get to bill for them because Sarasota didn't bill for them. In like manner refers, the logical construction is the process that's laid out in the act.
Follow up on that to make sure I understand something. Does Sarasota Memorial get these reimbursements as a government hospital and then the other private entities do not, or is it no one getting these after this ruling?
I'm not sure. Under the act, both Sarasota Memorial as a hospital that's owned and operated by the Sarasota County Hospital Board is entitled to reimbursement under the act, as are all other hospitals that provide indigent care to the medically indigent in the county.
Under the act as written,
yes.
The only part that's been held unconstitutional is the payments to the private hospitals and not the payments to Sarasota Memorial?
The trial judge did do that, Your Honor, and I really I could address severability, but I think that the county's pretty much conceded that the act probably doesn't make a lot of sense without the original intent that all hospitals would receive payment, and says, well, you can just strike the whole thing.
You're already at 9 minutes, and I'm going to give you 2 or 3 more minutes because we've been asking you a lot of questions.
Well, then I want to kind of jump quickly. I think where the trial judge went off track is on this issue of privilege under Article 3, 11A12. Not following that general rule of let's presume the statute is correct. She kind of like makes passing reference and says that the act provides for reimbursement to medically indigent residents of the citizens to the hospitals not operated by Sarasota County. So the plain meaning, yeah, the private hospitals would be entitled to it under the plain meaning of the act, and then she kind of jumps right into, but it's unconstitutional. And the reason it's unconstitutional is supposedly violates Section 11A12 which prohibits the grant of a privilege to a private corporation. And the wording of this is important because there is no private corporation that would be the benefactor of a privilege here. And I want to contrast this because what the judge did was relied almost exclusively on Lawnwood versus Seeger. And Lawnwood, I will tell you now, and I want to read something in just a minute. Lawnwood is the poster child of why we have Article 3, Section 11A12. And what that section was intended to do, I'm going to cite from a law review article that looked at these types of constitutional provisions in Florida's as well as other states' constitutions. The intent of these constitutional clauses prohibiting special laws is that such clauses were ratified to protect the people of each state from domination by narrow economic elites who would use their economic power to win grants of privilege from state legislatures. And these state prohibitions against special laws were supposed to fight corrupt favors garnered by private interests and address the problem of capture of the political process by economic elites and its conversions to a spoils system for their own gain. And when you look at Lawnwood, what happened in Lawnwood is you had a corporation that ran the hospital in St. Lucie County. And that specific corporation went to court several times with its doctors and was losing. They were losing the battle in court over hospital governance and credentialing and medical staff bylaws issues. And so what they did is they effected an end run and got a special law passed that says our hospital doesn't have to follow the general law anymore on hospital governance. We're going to have our own special hospital governance law because we want to overturn that. That's rife with the evil that was intended to be prevented by Article 3, Section 11A12. Now, compare that to this situation. First of all, where's the corporation that in 1959? Where's the corporation that this evil that was somebody was going to enact a law that was a spoils, was going to give something to somebody? HMA and HCA weren't even, they had not even come into an existence in 1959. So certainly wasn't to give HCA or HMA as a private corporation some benefit. No. What the legislature did is they said, we want to provide for the public welfare and the public good and ensure access and to provide hospitals that step up to the plate with a mechanism to be reimbursed so that they'll be financially successful and be able to do it.
It's about time for you to yield to Mr. Cantero here. So.
Okay. Do I have any time left on my rebuttal? Because I do have one. I'll shorten my rebuttal.
All right.
But this is an important point that I want to get to, and that is that there's sort of a companion or a sister provision in our Constitution that it's Article 7, Section 10. And that is the pledging credit, but when you read the provision, it says that the state cannot use or governments cannot use their tax power to give aid to a private corporation. Very similar type of language. That's been interpreted in numerous decisions, and I think they're instructive because what they say is, what is the government doing? Are they affecting a public purpose and there's an incidental benefit to a private company? If so...
But the cases that I've seen in the brief, those seem to all involve, or most involve, revenue bonds.
They do,
which do not implicate the taxing power of the government agency.
They do, but they're instructive because the whole point of those is that if the government is aiding a company by providing it with access to revenue bonds, and be that a theme park, a motor speedway, things much less important than what have been deemed paramount public purpose of healthcare.
The responsibility for payment doesn't fall on the taxpayers who are responsible for the ad valorem taxes. I mean, that's what I see as a difference on those cases.
I understand, but when you look at the language, Your Honor, there would be a dramatic inconsistency to say it's not aiding a private company to help them finance a sports stadium, but it is granting a privilege to a company when you say they have access to the same equal footing as a publicly owned hospital. All the hospitals are on the same footing. I know I've run out of time. Thank you.
Thank you. I'll save you 3 minutes for rebuttal. Mr. Cantero?
May it please the Court, Raul Cantero, along with Stephen Esenia. We represent Sarasota Doctors Hospital and Englewood Community Hospital. I'm not going to repeat all the arguments regarding the first issue, so I'll just add to what I think hasn't been discussed yet. First, I want to make clear from the record that the reimbursements we are seeking is for, number one, emergency care only, and number two, patients who do not qualify for Medicaid. We are not seeking any reimbursement for patients.
No duplications.
No duplication whatsoever. But unfortunately, and perhaps surprisingly to you, it was to me, there are a lot of patients that can't afford medical care and don't have Medicaid for some reason. They don't qualify. For example, a single male would not qualify for Medicaid. Those are the only charges that we're requesting. And we are not requesting any reimbursement at a charge that the public hospital would not be reimbursed at because the Special Act specifically provides that it's at the same rate as that paid to the public hospital.
So is it fair to say that the Act as written puts you on a level playing field competitively with Sarasota Memorial Hospital?
That's exactly right, Your Honor. That's the only thing it's designed to do.
And does the change that the Circuit Court has made give them an economic advantage in this situation or not?
Well, yes, they do, Your Honor. Yes, it does, because
you're passing on, presumably you're passing on the costs of these indigent patients to your paying patients.
Or we're losing money.
Or you're losing money, one or the other.
Yes.
And Sarasota Memorial does not apparently have to do that.
Correct. And let me add something else to the mix here, which is that at some point, the public hospital received the authority to impose ad valorem taxes. And so now, as you can see, they don't really care about this provision anymore because they say we can just tax, and they have taxed. Their ad valorem taxes have increased exponentially in the last 10 years, and they have authority to do so. So they're not even depending on this provision anymore. And so that leaves us with no way to get reimbursement.
Does it make a difference if you get this benefit in Sarasota? I mean, on a systemic basis, the private hospitals get a competitive advantage versus other private hospitals in other markets. And if we're looking at hospitals as systemic systems now within the state and elsewhere.
Well, Your Honor, that report that we attached to our brief in the appendix from the Governor's Commission, they say that these kinds of health care issues need to be determined on a local level. There's nothing there that says that competition among hospitals crosses county lines. And in fact, that's why there are so many special hospital districts in Florida, is because it's so localized in each of those hospital districts, and it's in this report as well as in the Tax Watch report that's attached to that report, which goes through the history and how many special districts there are. There are independent special districts, there are dependent special districts, there are those that have ad valorem tax authority, those that don't. It's a whole mix, but it's all because it's a very localized issue.
And I'm not sure that it fits into the constitutional argument, I'll say that right up front, but one of the things that concerns me a little bit, going back to the economics of this, is that if the legislature forces the citizens of Sarasota County to tax themselves to pay for indigent care, and doesn't force the citizens in Manatee County or Collier County to do this, then a couple things happen. Hospitals are a lot happier when they're in Sarasota County than when they're in Bradenton, and on the other hand, private businesses that paying taxes are more likely to locate in Manatee County than in Sarasota County. This starts affecting economics of a region it's not statewide, and it's the legislature doing this, not the local county commissions. That just
Yes, Your
is
Honor.
troublesome.
And I think that's something for the legislature to address and perhaps to fix across the board. But it's certainly, as you said at the beginning of your statement,
It has
it's not.
nothing to do with privileges
right.
of a corporation.
Correct.
Yes, that's right.
And getting back to that provision, the county and the district argue, as Judge LaRose was saying, that you have to look at their competitive advantage over other hospitals in other counties. The provision says that you can't enact a special act that grants a privilege to a private corporation. So to break that down, there was a couple of important phrases in that. Number one, special act, because a special act by definition only applies to a local community. So it's not a general law cannot grant a privilege to a private corporation, it's a special act. So you have to look only at Sarasota County or whatever county we're looking at, not across the state, because by definition it's saying a special act cannot grant a privilege to a private corporation. The second important phrase, I think, is a private corporation, not private corporations in general, not private parties in general, but a private corporation. And this goes back to what Mr. Smith was saying, which is the whole point of this provision is to make sure that a certain company...
The argument is then the Constitution, the exemption in the Constitution is for a specific corporation as compared to a class of corporation?
Correct, correct.
Is there any case law that interprets it one way or the other on that?
No, except the Seeger case did involve only one corporation that had two hospitals, and that was important to the court in that case. And it was important that there were no other hospitals in the county at that time. And as Mr. Smith said here, these hospitals didn't even exist in 1959, so they weren't designed to grant a privilege to anybody. And as Judge Altenburn said a few minutes ago, it was clearly designed to put private hospitals and public hospitals on the same playing field.
But is there an explanation for, I guess, maybe a historical anomaly? Under this special law, it's mandated that the private hospitals
Yes.
reimburse. As I understand, there's similar special laws for other districts in the state, but it only authorizes as opposed to mandates.
You're
Is there an
correct.
explanation for
You're
that
correct.
difference?
I couldn't find any explanation in the legislative history or anything like that, but you are correct that that's what it does, and that's, I think, why we're here, and that's the county's objection is, I think if it were permissive, they wouldn't be objecting so much. They're objecting because it's mandatory. If I'm prepared to address the home rule charter argument as well, Your Honor.
And I would like to have you spend a couple minutes on that, if you may.
Yes, Your Honor. Well, as to the home rule charter, they have cited no case that says that once you adopt a home rule charter, any special law relating to that county enacted, even before then, is now automatically repealed. No case like that exists. There is a case, the Pinellas County versus State case from the Florida Supreme Court, and I'll be honest with you, it doesn't directly address the issue that we're involved with, but it did apply several special acts adopted in the 1940s and 50s regarding the authority of Pinellas County to assess fees for water supply and to establish water supply in Pinellas County, and applied it to Pinellas even after Pinellas County became a home rule county in 1980. That's the only case that I have found that really addresses it one way or the other. The other authority that we have cited, and it's not a case, but it's the Attorney General's opinion from 1981, it's 81-07, and there the Attorney General stated, and the issue was whether if Hillsborough County becomes a home rule charter county, can it then repeal special acts that were enacted before it became a home rule county? And the Attorney General said no. It says, while the Constitution as amended authorizes a county government to be established by charter pursuant to general law neither Section 1C nor the implemental legislation empowers a charter form of county government to amend or repeal any statute theretofore enacted by the state legislature. And then it goes on and says, the power to amend or repeal the statutory law is a legislative power belonging to the state, which is, by the terms of Section 1, Article 3, vested in the state legislature. In the absence of some express constitutional authority, therefore, it would seem axiomatic that existing statutes may be amended or repealed only by another statute enacted by the state legislature. So that's the only authority we have, and it stands to reason that when a county becomes a charter county, that it takes the law as it finds it before the enactment of the home rule charter and subject to. And no case has ever said otherwise. Now, assuming for the moment that the county is correct that at least as to subsequent special acts that the county charter would trump, the only thing we have here is in 2003 where the legislature incorporated all of the special acts. By then there were 29.
Pull them all into one.
Yes.
They did across the state.
There were, and as to Sarasota County, just as to the hospital board in Sarasota County, there were 21 special acts between 1949 and 2003. And what it did is say we're going to consolidate all these special acts and other special acts into one act so that people don't have to go and find all these. It's just going to be in one law. And the Florida Supreme Court said in McKibben that when that happens, when all you're doing is reenacting laws and you're not substantively changing it, that it relates back to the prior iteration of the law.
You're probably running into the rebuttal time at this point. So.
And then I'll sit down, Your Honor.
Okay.
Thank you.
Good morning or afternoon. Tom
I'm
Elliger.
assuming you're the only one arguing for the county today.
I am today, but I am joined by County Attorney Stephen DeMarsh and Assistant County Attorney Rick Elbrick. I'll plan to do 20 about, and hopefully less, and then Mr. Wallace for the district.
Pick up. All right.
I'll start with the privilege argument. The Constitution is very clear. There shall be no special law pertaining to a grant of privilege to a private corporation.
What in this special act refers to a corporation?
I'm sorry, what now?
What in this special act says that they're making payments to a corporation?
That would be the portion of 8(9), I think the third paragraph, that may reimburse any other hospital, so it shall in like manner.
So Bill Gates gets in his mind that he wants a hospital. He comes to Sarasota County and he builds himself a hospital. And then he comes and submits a bill for the indigent care at his emergency room. There's no corporation. Who's being privileged?
I'm sorry, what?
There's no corporation being privileged.
Well, he didn't incorporate the hospital that he built?
No, he doesn't need to. He's Bill Gates.
Okay, well then in that case, there may be some other problems with that, but to correct something.
I mean, on its face, there isn't a corporation the legislature was looking at. And,
no.
And if you go back to 1949, it actually wouldn't shock me at all that there were a bunch of hospitals that were not, in fact, incorporated.
This section was added in 1959.
59.
To answer an earlier question, the 1949 Act was passed by referendum. The 1959, which added the 8(9) that's offensive, was not passed by referendum. There was no referendum on that. So that has never...
But there's no argument about it having been defectively enacted, is there?
Perhaps not under the 1885.
There either can be notice or referendum under the Constitution, right?
Under the 1968 Constitution.
Yeah.
And this, it's a little bit mixed, but I mean, the privilege standing alone is a fatal problem. The home rule is another problem. But I'd like, the privilege this is a grant of a privilege to a private corporation. Whether one wants to say historically that's not really what was intended or whatever, that's certainly what they're intending to do with it. And the argument that, well, it's a corporation, that's clearly not what the Constitution means. If you could subvert it that way by saying, okay, we're going to pass a special act for Corporation A, and then pass a special act for Corporation B. They're all in the same county. The problem is it's a special act in the one county. It mandates these payments under the plain wording, assuming there have been payments in like manner to.
Why isn't it just an act that puts private hospitals on the same footing as a public hospital?
Even if that were true, which...
Well, is it true? I'm not...
No, well...
It sounds to me like that's what it's doing, but
actually,
maybe I'm misunderstanding it.
They already are on equal footing because there's been an ordinance. There have been ordinances in effect during the 60s and Ordinance 72-79, which allows any of the hospitals, public, private, to come to the county and ask for reimbursement. And they have indeed done that. And that payments have been made.
That's a permissive statute as compared to mandatory?
That is a permissive statute, yes. Yes, to get back to earlier questions. And that's fine. And that's like all the other ones in the state that you're talking about. And if it's a local...
This is a unique mandatory one.
If it's a local decision, as I heard said a few moments ago, it should be decided locally by the county commission, not dictated to them by the legislature.
And I don't disagree with that, but I'm trying to find out whether that's a constitutional requirement or not. It is a constitutional prohibition to have a special law that favors a corporation. The privileges.
To have grants privilege. There's no question that making somebody pay money is a privilege. The reason it was discussed in Longwood is because there was a debate about, well, is having this review thing a privilege? Financial money paid directly to a private corporation, there's no question that. They don't even dispute that's a benefit. That's a privilege.
Longwood, there is this dispute between the hospital and its docs or whatever, and,
yes.
and then they go to the legislature to
yes.
fix this problem.
Yes.
Here I have a statute which was historically probably did not look at or contemplate private corporations, and we could probably envision any number of organizations that could run a hospital that are not corporations.
Right.
And that would not run afoul of the Constitution to require them.
It may not. That's the first time that's come up, and I want to think about that. It may not be a violation of the privilege provision. There may be some other problems with it. We may be getting a home rule problem dictating how you're going to spend local dollars. But there may be other problems with it. But here, this is, I mean, they want to make the argument you should look and compare our profit hospitals to the public hospital. That's clearly not the correct analysis. For one thing, if that were, and I mean, two things. First off, if you look at the district court opinion in Longwood v. Seeger, you will see that it says they are the only, those two private hospitals, the only two hospitals in the county. So all this discussion in the Supreme Court decision about is it a privilege, there's never a discussion comparing it to public because that's not relevant. The question is, does it give a privilege to a private corporation or corporations? And the answer to that's yes, we're done. It's unconstitutional.
Relative to the other private hospital?
Yes, when you look and you say, okay, do they have that in Hillsborough County? Do they have that in Pinellas County? If the private if they pass it statewide and they said, look, here's how we're going to deal with this statewide, everybody's going to pay the private hospital some percentage for something, that's a statewide law. So that doesn't violate the privileges for the privilege prohibition under a special law. The problem here is the Constitution is very clear. You can't do what they're using this law to do, whether it was ever intended to or not.
If I have an inhabitant of Sarasota County that gets treated at a private hospital in Charlotte County or Manatee County, under the terms of this special act, can they ask for reimbursement? I don't know the answer to that.
I guess I'd have to
Does the
look back.
hospital have to be inside the county, or is it just, because I can see an inhabitant, especially given the cloudiness of the line between Manatee and Sarasota County.
Well, it says Board of County Commissioners shall in like manner reimburse any other hospital in Sarasota County. Okay, and to briefly digress to a point that was made in the first argument, that's not a procedural description.
I was going to ask.
In like manner, yes. The in like manner is a trigger. I mean, if this were constitutional, which it's not, there would have to be payments to the public hospital, which there have not been. I mean, we believe the record's clear, and the person was deposed, Mr. Jimison, he says, those payments have been made under 72-79, the ordinance, or some prior ordinance. He's the one that oversaw it. They cite a bunch of papers that don't tell you where they come from. Some of the papers, in fact, I can find you the site, there's one of them that actually has a listing in it, and it shows from 97 to 2007, paid under ordinance 72-79. And all of these hospitals, public, private, they've all gotten money under that. Under the ordinance, the discretionary ordinance, which is the way it should be. But then to follow up on Judge Rose's earlier question, the Section 8(9) then goes on to say, in like manner for the hospital, provided herein, upon like certification by such hospital at such rates. The upon like certification is the procedural thing. What do you do? Okay, here's how you do it. You give them a like certification that we've treated these people. And then you get paid in like manner if the public hospital's been getting paid, which they haven't been. So that's a factual problem they have. That's one of our alternate grounds is under this record, we've shown the payments were made under the ordinances. There is no in like manner. They don't qualify. They don't get anything even if it were constitutional. I know they say, hey, there's disputed facts. We've laid out what the facts are. We don't think having an affidavit from somebody who says, oh, we learned they were being paid under the special act with no basis, a conclusory statement, creates a fact dispute. But
we're reviewing these issues de novo, as we should. As the argument's gone on, I've gotten a little more concerned as to whether or not we actually have an adequate factual basis in the record to make certain that we can declare this thing facially unconstitutional.
It's a privilege to a private corporation. And to get back to where we were, the comparison is private to private. And here's how you know, because not only is that what's discussed in Seeger, and when you look back at the DCA system, you see that, but let's look. I use an example in my brief, which they said, oh, well, those are free services. What happens if, let's go to our neighboring county. We're all from Hillsborough County. Hillsborough County has an office building. I assume it pays somebody to take care of the office building, janitorial. Hillsborough County pays its employees. It's headquartered in Hillsborough County, that's Hillsborough County. Can the legislature pass a law that says any private corporation headquartered in Hillsborough County, the county's now going to pay for its office cleaning, for its employees? That would be a privilege to a private. That is the equivalent of what this is. That's what this is. I used the example earlier.
To something Judge Altenburn said, aren't we better teed up if the private hospitals make a demand for payment and there's actual evidence that the public hospitals got the money, and then we have a more concrete dispute? Because right here, it appears to be, if we take your position, the public hospitals have not gotten into this money. And if in like manner is something other than procedure, maybe this isn't teed up right.
Well, and that's why I raised that at the end of my answer brief, saying I know you like to reach things on a non-constitutional basis. They're disputing that. If they want to come in and say, and I think it's very clear in this record, there may be some ambiguities of what happened in the 60s. These acts have been here. The ordinances have been here since like 1960, the different ordinances under which payments have been made. And it's our position that's what the payments have been made. They say, oh, no, there have been some payments under the special act. I don't see a single piece of paper that establishes that. I see the testimony of the person who was in charge of the payment saying, no, we didn't do that. I mean, the pertinent time I would suggest would be 2003 going forward when it's reenacted, that we're here on the 2003 Act. I don't think you can see anything from 2003 up through 2000, through the time of trial that says, here's a payment that was made to the public hospital under the special act. So, yes, there may be a non-constitutional basis. They dispute that. They say, oh, we got disputed facts on that. My response is, if there is no disputed fact that has to be resolved on the privilege issue. They say that in their briefs. On the privilege issue, it's teed up. It is, the constitutional issue is there.
Was this filed as a deck action? Or what? I suddenly realized I don't quite know what the complaint looks like. They're shaking their head up and down, yes, that it is. I'll take that as an answer.
Thank you. I'll take that too. So, again, private versus public, irrelevant. Private versus private in other counties, other special areas, or other different geographic areas. That's what makes it a special law. That's what makes it prohibited. And the simple example we just talked about of, well, are you going to let the legislator dictate who the county has to pay for something in this private corporation in a county simply because they provide some equivalent public benefit?
In your example now, the legislature would have to subject it to a referendum of voters in Hillsborough County, or give notice.
Right.
So there is a popular check on the special law.
And that might be a good time to segue. I'm happy to try to answer any other questions on privilege. I think I've covered what I wanted to there. There was some talk about, I think I heard it come back today. There was something in one of the reply briefs about, we're not saying you have to, we're just saying it authorizes. No, I think what I heard again today, their position is we have to pay them, and that is their position. And that is, they can apply under the ordinance. And indeed, the record shows they have been paid under the ordinance. I can find that site if it's important, but the chart is at page 489. It shows 10 years or so of payments under the ordinance, 72-79. On the and I'm not sure how I'm doing on time.
You're 13 minutes in.
Oh, okay. On the other constitutional infirmity here, and that is that by telling Sarasota County you must use your tax dollars for this, they have violated Sarasota County's charter home rule powers. Power to spend the money it's hard to imagine anything that would be more important to a county than being able to decide how it's going to spend its money. And I would agree with my friend Mr. Cantero that there is no case directly on point on this issue. The Birdsong case we think is close, or at least instructive, because what happens in Birdsong is you have a tax that was allowed under the old Constitution. The '68 Constitution comes into effect. The Supreme Court says, hey, it's no longer allowed. It's been knocked out. Now, our position is when the '68 Constitution came in, for one thing, it prevents the privilege to a special law privilege private corporation. That's issue one. We win on that. But separate and apart from that is it authorizes charter counties. Once Sarasota County becomes a charter county in 1971, then there cannot be a special law. The legislature cannot dictate to Sarasota County how to spend its tax dollars, which is what this purports to do.
Does it make any difference that a specialist general law at that point? They pass a law that says that all counties have to have American-made flags in their county courthouse, so the county has to buy American flags.
Your Honor, that is not a not a special law granting a privilege, and B, it's not a.
But your home rule thing is not dependent upon this special act granting privilege.
Correct. That is also. You can pass general laws, and that's part of the problem with many of the cases cited in the reply brief.
But I guess my question is the home rule argument distinct to special acts as compared to general acts? I'm not sure.
Yes. If it's a general law, the home rule argument is not applying to it. Right. Yes, absolutely. Okay. And the cases, let's see, the Sandgren case, the Coastal Recovery case, the Board of Public Instruction, those are all statewide statutes, completely irrelevant to this analysis. Birdsong, I think, is instructive. The other case, we'll talk about the Sarasota case, Pinellas County case.
15 minutes right now, by the way.
I'm sorry?
So you're just past your 15 minutes.
Okay, thank you. We're going to do 20 and 10, but thank you. The Pinellas County case was a situation where there were prior existing special acts that granted powers to Pinellas County. And in fact, this court, or the opinion at page 264 says the county was authorized by its home rule charter powers and the special act to add reclaimed water improvements. In other words, they weren't dictating to the county to do something, they were giving it power and authority. That's fine. When you say you've got to spend your tax dollars that way, that's a problem. I think the Homestead case is on point. They say, whoa, Dade is unique. Dade was the first charter county, but it's still a charter county, so are we. So is Sarasota County. I think the reply brief at page 7-8 in Venice tacitly, not even tacitly, recognize you have to have a referendum, a vote of the electors mandated by the '68 Constitution, but it says special laws adopted under 1885 don't need that. Well, this was readopted I agree. There are cases that talk about, well, if you've just done a ministerial thing and you put this in, the statute stays in place because you don't want somebody to no longer can be tried for the crime and so forth. That's not what we have here. We have an intervening constitution and an intervening charter government that has been formed with specific powers under the Constitution. That is a different scenario. Just to clear up a couple things, I don't believe the stuff about them only seeking money when they've been paid. That may be what their position is, but I don't think that's on the record about saying only seeking money for not being paid for Medicaid. In fact, if you look at the letter at page 291 of the record, the doctor's hospital letter refers to they're seeking money because they're something called not being eligible for retroactive Medicaid. I'm not sure what that is, but if they're too slow in filing something, that shouldn't be the county's burden in any circumstance. I think that's all I have unless there are any questions from the court. We would ask that you affirm.
All right. Mr. Wallace?
Please, court. David Wallace from the Williams Parker firm in Sarasota, here on behalf of the hospital district. Just to be clear a little bit about who the district is and where we fit with the county, the district is an entirely separate governmental entity from the county. We're sitting at the same council table, totally aligned, but totally separate governmental entity. With me behind the bar is Carol Ann Kalish. She's the chief legal officer for the district and was the trial counsel for the district in this case. The district has an elected board, the Sarasota County Public Hospital Board, that operates the hospitals and other healthcare facilities in the district. I wanted to jump to severability for a moment just to make sure I thought I understood a consensus, but I want to make sure we're there. On severability, the trial judge severed the third paragraph of section 8, paren 9, which is the only paragraph of the act that was added in 1959, the only paragraph that deals with hospitals other than the public hospitals operated by the district. So the trial judge severed just that third paragraph, finding that the special act as a whole was complete without it, would have been passed without it, and was substantially different in content than that third paragraph. And indeed, the main point is, as to the would have been passed without it, it in fact was passed without it, because we know that the special act as a whole was passed in 1949, and the provision, section 8, paren 9, that we're talking about was added in 1959. So the trial judge severed just the third paragraph.
And let me make sure I don't have it right in front of me,
Yes.
so I want to make sure I understand this. It hasn't severed out the right of the public hospitals to seek reimbursement.
Correct. The judge severed just the third paragraph.
Even though you've apparently been making your request for reimbursement under a permissive ordinance,
Yes.
the special act still has on its face a right for you to seek mandatory reimbursement from the county.
On its face, correct. However, Your Honor, below and here, we're arguing that the entire section 8-9, joining with the county and in our own arguments, that the entire section 8-9 is unconstitutional. As you've said, we're not claiming reimbursement.
But the trial court only knocked out a part of this.
That's correct.
Okay.
The trial court knocked that apart, and to get what I think is the final point on severability, when you look at the private hospitals briefs, and if I understand Mr. Smith correctly, when you look at the private hospitals briefs on severability.
So did the trial court err by not knocking out enough?
Well, we would agree that the trial court could knock out the entire section 8, paren 9. The private hospitals argument is that you shouldn't take out the third paragraph without taking out the rest of section 8, paren 9, which they call the indigent care provision, to which we responded in our answer brief, okay with us.
Okay.
That's okay with us. You can take out the entirety of section 8, paren 9.
Because if the entirety is knocked out, any concern about what I'll call the level playing field goes away.
Yes, yes,
All right.
I believe so.
I don't know go ahead, I'm sorry. I didn't know who I should ask, but I'm going to ask you, what happened in '59 that changed the lay of the land in Sarasota County? Were there non-public hospitals coming on?
There was the other hospital that existed at the time was the Venice Hospital.
Right.
I don't think it was owned by the same corporation that owns it now.
But it was that was a non-public hospital that...
Yes, I believe so, and I believe the record reflects that. And of course, at the time, the old Constitution had a requirement to care for the medically indigent.
Right. Right.
And then at the time, I believe there was a statute of statewide application that also had a similar requirement. That requirement was left out of the '68 Constitution. But the '59, so the context of what was required by the Constitution and the general laws was different in 1959. In other words, the hospital put into place, in essence, procedures around what the constitutional authority was then, and the general laws were then to implement that.
But was Sarasota Memorial the only one in existence in, what was it, '49, I guess?
Yes, well, the district was created in 1949.
Right.
The district created then and operates now, Sarasota Memorial Hospital, it's the only public hospital operated
Were there any
under the
other
district.
hospitals? I'm just,
Yes.
historically, in '49, was there any other hospital?
Oh, well, I don't know of any other public hospital, and I don't know whether Venice existed in
Okay.
'49. I understand they existed in '59.
There would have been a black hospital.
So with regard to severability, yes, I believe that if you took out the entirety of Section 8 and 9, the level playing field question goes away. I don't think it's a active question anyway, because we haven't been using the mandated provision. We've been using the ordinance to the extent we use anything. But the judge took out the one paragraph. She could have taken out the entire section, and that would have been okay with us, and that appears to be what the appellants are arguing for if you get to that point. The other issue I wanted to address is one of the other alternative arguments, if you will, alternative because the judge based her ruling on privilege. Mr. Elliott addressed home rule. I'd like to address vagueness for a moment. And Judge LaRose, the point that I think is the key point that we have for vagueness is this definition of medically indigent person, and that's kind of where you started with your questioning about 40 minutes ago. And it has to do with the context of their claims for reimbursement here. We believe that phrase is unconstitutionally vague, particularly because it illustrates this point, that what they're claiming is all emergency patients. All emergency patients. By the time an emergency patient walks up to the front door, that emergency patient is required to be treated under general law by these private hospitals to the point of stabilization. And if you look at, but clearly because they're claiming all of these reimbursements as emergency patients, clearly they believe that patient, even though general law requires treatment, that patient's still medically indigent.
What definition of indigency are they using when they're submitting these things?
What definition are
The
private?
hospitals.
Well, the definition that's in the Act is an inhabitant of Sarasota County who is ill or injured and who requires treatment in a hospital as prescribed and ordered by a physician, and I think this is the key phrase, and who is unable to provide himself with such necessary hospital services. There's no mention of payment. Unable to provide himself with such necessary hospital services. And if the easy illustrations are, you could have someone that's indigent in conventional terms, no money in their pocket, but they have insurance. So that person's not medically indigent. That person can provide for themselves the medical care that they need by pulling out their insurance card. Likewise, if someone qualifies for Medicare or Medicaid, that person's not medically indigent with regard to the care they can get through Medicare or Medicaid. We would extend that, and I don't think it's actually an extension, it's a logical application of it, to the general law requires that someone who presents themselves to an emergency room gets care to stabilization, and you can't even ask, unless if it's possibly going to delay treatment, you can't even ask about the ability to pay. So that person gets that care, and just by walking in the door has been able to get themselves those necessary hospital services.
Because unless we regard everyone who doesn't pay their bill as fitting into this category, you have to have some sort of, I guess, individualized financial affidavit and some thresholds of some sort that would be created outside the act to decide indigency.
My understanding is the county does some sort of analysis like that under their ordinance. But if you, I think the dividing line that I'm suggesting is, do you have other means to provide yourself those medical services that are required here? And I think there was reference earlier to access statutes, and is this an access provision? Well, I think this was an access provision. This was designed to make sure that somebody can get the hospital services that they needed. Now, 50 years later, EMTALA was passed in the 1980s, I think 1988, both federal and Florida. Actually, I'm not sure what dates, but Florida was in 1988. So now that patient is able to get those services. And I think that at least HCA in their brief, in their reply brief, it was in a slightly different context, but I think they kind of recognized what we were saying. This is from page 2, I believe, of the HCA reply brief, where they were comparing public schools and healthcare and police, and noting that healthcare is not provided to all citizens, but public schools and police are. And then they say, indeed, if it, meaning healthcare, was provided, there would be no medically indigent persons. We agree. If healthcare, if you have access to that healthcare, you're not medically indigent under this definition. And so our interpretation of medically indigent person is very, very different than their understanding of medically indigent person. And all of their claims work under their definition, don't work under ours. We think that's unconstitutionally vague.
We've got about 3 minutes left.
Okay, I'll hit one more point and then I'll sit down. The one more point is actually quite similar. Also under the vagueness of the term hospitalized. Again, there's a simple definition. I think one of the private hospitals quoted Webster's. Hospitalized is to place in a hospital as a patient. Okay. Inpatient or outpatient? And that's my question. I think there is a vagueness question there. Inpatient or outpatient? And in this case, again illustrated by the emergency room, all of the claims are for emergency room patients. If someone who walks in, goes to the emergency room, is that a hospitalized patient? We suggest no. They say yes. That's a vagueness question as well.
What would your position be? It's not until they're formally admitted?
Admitted as an inpatient.
Admitted as a patient, which
Yeah.
is subsequent to emergency room treatment?
Yes, that would be my interpretation of it. I think there are all sorts of clinics, or there exist clinics where
So you've got walk-in clinics that are owned by hospitals and some that are not.
some that are not,
Here in
right?
Sarasota County.
And I guess my point would be that is the person that receives the very same care in the one owned by the hospital hospitalized, and the one that receives exactly the same care in one not owned by the hospital not hospitalized for receiving the same care and not becoming an inpatient. So we believe that term is unconstitutionally vague as well. Unless there are any more questions, I'll.
Okay.
Thank you.
I will try to be as brief as possible and fast as possible. First of all, I want to go back to something I believe, Judge Loros, you may have said. This isn't teed up properly. We don't have a factual record. And I just want to pause to say, if you read the trial judge's order, it's completely devoid of any kind of factual finding, any kind of factual underpinning. So you can't make these leaps to things of, well, those payments were only made under Ordinance 7279. there's some confusing stuff in the record, but you know, our guy says they were made under 72, 79. He may not have been there at the time when those payments were made, but he says that you can't make these leaps. There's no factual underpinning to make them. The second thing, going back to the home rule for just a moment, I think it's important to point out two cases cited in our brief, Hillsborough County versus Tampa Port Authority and Bailey versus Ponce de Leon Authority. And both of those cases dealt with the issue of a special district created prior to the 1968 Constitution. And there were changes made to those special tax districts afterward, which under the 1968 Constitution would require a referendum of the electors to make those changes. What the court, including the Florida Supreme Court, held in those cases was they weren't required to, and they relied on a savings clause. Well, there's a savings clause that is at issue here, and that is Article 12, Section 6 of the 1968 Constitution that says, all laws in effect upon the adoption of this revision, to the extent not inconsistent with it, shall remain in force until they expire by their terms or are repealed. That's the general rule of law. The statutes don't expire by non-use. They don't expire because there's other laws that might address the same topic. They only are either repealed or they expire under their own terms. I'd just cite a couple cases. I'm not sure. I would refer you to the record, and it is in the response to motion for summary judgment, and it's State versus Gadsden County, 58 Southern 233, and Littman versus Commercial Bank, 425 Southern 2nd 636. And then at our record on 379, there's a series of cases that discuss the whole issue of you can't repeal by non-use of a statute, and I would address State versus Egan, 287 Southern 2nd 1.